Imagine finding out the rules of an upcoming election, and even what congressional district you live in have changed just hours before the voting rolls lock. Today, we are exploring how a seemingly obscure legal doctrine and a clash of constitutional ideals caused exactly that. If you enjoy content like this, please take a moment to like, subscribe, follow, and turn on notifications so you'll always know when new content is released. As a quick update, we continue to monitor the Martin Stevens v. OpenAI matter. It is important to note that this is still not a lawsuit. We remain in a voluntary quiet period at the request of Martin Stevens to allow time for any potential developments behind the scenes. At the time of this recording, we do not know whether any progress has been made. No settlement discussions or negotiations have been publicly confirmed. We can also report that the dead man's switch has not been activated, meaning Martin Stevens remains safe from both a physical and legal standpoint. We will provide updates if circumstances change.
Yeah, and while we wait on that Stevens front, the legal upheaval we are looking at today at the Supreme Court is just, well, it's massive.
It really is. So, for this deep dive, our mission is to explore this completely tangled web of federal election law, congressional redistricting, and this highly controversial rule known as the Purcell Principle.
Right.
And to do that, we're pulling from a bunch of different sources. We've got actual Supreme Court opinions, detailed legal analyses, some law review articles, and news commentary from both, left-leaning and right-leaning perspectives.
Yeah, and because we are dealing with those different perspectives, I need to clearly state to you, the listener, that our sources contain politically charged viewpoints regarding race, partisan advantages, and judicial behavior.
Right, which gets heated.
Exactly. So we are not taking sides here. We're not endorsing any of these specific viewpoints. Our goal is just to impart the factual content and the ideas contained in the original source material just to help you understand the debate.
Yeah, just laying out the facts. So to really understand how this conflict plays out on the ground, we have to look at Alabama. That's where this legal drama really reaches a boiling point.
It's the perfect case study, honestly.
Right. So demographic context for you here. Alabama is a state where the black population is over 27%, right?
Yeah.
And the state has 7 congressional districts.
Right. So if you just do the raw math.
Exactly. 27% of 7 districts is basically 2 full districts.
Yeah, almost exactly 2.
But following the 2020 census, the state legislature's 2021 congressional map packed black voters primarily into just one of the state's 7 districts.
Wow.
Yeah, so that is just 14% of the state's representation for a population that is, nearly double that size.
Right. And the timeline of what happened to that specific 2021 map is critical here. It's how this whole thing escalated into a national legal showdown.
Okay, so walk us through it. What happens first?
So in early 2022, a federal court blocked that 2021 map. They ruled that it unlawfully diluted black voting strength through this practice that map makers call packing and cracking.
Poking and cracking.
Yeah, so packing many minority voters into a single district to just minimize their influence everywhere else, and then cracking the remaining population across several other districts where they are just constantly outvoted.
Right, so their voting power is basically neutralized.
Exactly. So the lower court demanded a new map, but then the Supreme Court stepped in.
Oh, here you go.
Yeah, they stepped in and temporarily allowed the diluted map to be used for the 2022 midterms anyway. They basically cited how close the election was.
Okay, wait, so they knew it was flawed but said just use it for now.
Basically, yeah. Which set the stage for a massive surprise in 2023.
Right, the Allen v. Milligan case.
Exactly. In that ruling, the Supreme Court affirmed the lower court's block. They explicitly ordered Alabama to draw a second opportunity district.
And an opportunity district is...
It's a district where black voters would have a realistic mathematical chance to elect a candidate of their choice.
Okay, so the Supreme Court literally gives a direct order. Fix the map. And the Alabama legislature's response to that direct order is what kicks off this whole chain reaction. Because they enacted a new map in 2023 that still only had one majority black district.
Yeah, they just defied the order.
Completely. So a 3-judge panel struck it down again, noting the overt refusal to implement the remedy. And the panel actually had to appoint a special master to draw a fair map.
Right. They took it completely out of the state's hands.
It's like I was reading this and thinking it's like a referee penalizing a football team for an illegal formation. Right?
Yeah.
And the team just lines up in the exact same illegal formation for the next play, but they just swap the jerseys of the wide receivers.
Yeah.
Just banking on the idea that the ref won't throw the flag twice.
That is a great analogy, and the reason the state legislature felt emboldened to run that exact same play again is because map makers right now are trapped in this massive, unresolved contradiction in American constitutional law.
The two masters, right.
Exactly. They are serving two masters at the exact same time, and these masters are giving fundamentally contradictory orders on how to handle demographic data.
Okay, let's break that down for the listener. Who are these two masters?
So on one side, you have Section 2 of the Voting Rights Act, under a famous precedent known as the Jingles test. From Thornburg v. Jingles, the law sometimes requires states to actively consider race when drawing maps.
To prevent that vote dilution we were just talking about.
Right. If a minority population is large enough, compact enough, and politically cohesive, meaning they, generally vote for similar candidates,
Yeah.
then the state has an affirmative obligation to ensure their voting power isn't being drowned out. So a map maker literally has to look at racial data and draw lines accordingly.
Okay, that makes sense. But what's the other side?
The other side is the Equal Protection Clause of the 14th Amendment. That clause severely limits the extent to which race can predominate in government decision-making. Yeah. It warns states that if you use race as the primary factor in drawing a district line, you've created an unconstitutional racial gerrymander.
Wait, how is a state supposed to realistically navigate that?
That's the million-dollar question.
I mean, how do you account for race enough to satisfy the Voting Rights Act, but not so much that you violate the Constitution? It feels like asking a baker to make a cake that prominently features the flavor of vanilla, but legally forbidding them from looking at the measuring cup when they pour the extract.
Yes, exactly.
Especially in regions like the Deep South, where, race and partisan voting patterns are so historically deeply intertwined.
Yeah, they are practically layered on top of each other. And that tension is what's driving all this litigation. It's an incredibly difficult needle to thread.
Right.
And the Supreme Court recently tried to clarify the rules in a 2026 decision called Louisiana v. Calais. They updated the Jingles test with a major new directive.
What did they say?
They stated that race and politics must be disentangled.
Disentangled. Okay.
Boy.
How do you even prove that?
Well, under this new Calais standard, the burden of proof shifted heavily onto anyone challenging a map. If plaintiffs want to prove a map is discriminatory, they now have to show that their proposed alternative map meets all of the state's legitimate districting objectives just as well as the state's map.
But without using race as a criterion.
Exactly.
Okay, we should definitely define legitimate districting objectives here. Because in the Alabama case, the state argued that one of their primary non-racial goals was keeping the Gulf Coast communities together.
Right, specifically Mobile and Baldwin counties.
Yeah, they argued those counties should be in the same district because they share coastal economic interest.
Which means, under the new Calais standard, if a plaintiff draws a proposed map that fixes the racial dilution, right?
Yeah.
But that new map happens to split Mobile and Baldwin counties, the court can rule that the proposed map doesn't perform just as well on race-neutral grounds.
Oh, wow. So the state's map just survives.
Yep, the state's map survives.
Yeah.
And there's actually another looming issue threatening this whole framework. If we look back at a specific detail from Justice Kavanaugh's concurrence in that 2023 Milligan case, he dropped a major hint about the future of the Voting Rights Act.
Uh-oh.
Yeah, he suggested that the authority for race-based redistricting under Section 2 might have an expiration date.
Wait, really? An expiration date?
Yeah, he wrote that it cannot extend indefinitely into the future, basically inviting a wave of new legal challenges, arguing that the Voting Rights Act's core enforcement mechanism has, passed an undefined sunset date.
That is huge. But it feels like the foundation of the Voting Rights Act is facing these slow-moving philosophical legal battles.
Right, they take years.
Exactly. Years of lower court trials, appeals, Supreme Court briefings. But elections don't care about legal philosophy.
No, they definitely don't.
They happen on strict, unforgiving timelines that are just dictated by the calendar. So what happens when these slow-moving legal tectonic plates collide right before voting is supposed to start?
Well, that's when the courts have to rely on a procedural rule rather than a constitutional one. And that brings us to the Purcell principle.
Okay, the Purcell principle. Explain this one for us.
So this doctrine stems from a 2006 Supreme Court case, Purcell v. Gonzalez. It dealt with Arizona voter ID laws.
Right.
The core idea of Purcell is just that federal courts should not alter election rules too close to an election.
Because it causes chaos. Right?
Exactly. The logic is highly pragmatic. Last-minute changes cause administrative chaos for local officials. You know, they have to suddenly print new ballots or reassign poll workers.
Right.
And that leads to voter confusion. And voter confusion ultimately depresses turnout, which harms the democratic process itself.
Okay, but the sources we looked at highlight a massive critique of how the Supreme Court actually applies Purcell in practice today,
Oh, yeah, big time.
because it is almost exclusively used on what legal scholars call the shadow docket. And for anyone unfamiliar with that term, the shadow docket refers to emergency orders the court issues completely outside of its regular lengthy review process.
Yeah, there are no full briefings, no oral arguments where the lawyers get questioned.
It's often just like an unsigned late-night PDF drop.
Literally.
So you have the Supreme Court making these massive, landscape-altering election decisions without fully explaining their legal reasoning, or even detailing how they weighed the facts of the lower court's trial.
And that lack of transparency frustrates legal scholars immensely. I mean, it makes it nearly impossible for lower courts or state legislatures to know exactly where the line is actually drawn.
Right. And CNN analyst Steve Vladeck raises a point in our sources that gets right to the heart of this frustration.
Oh, Vladeck's point is brilliant here.
It is. He asks, if the Supreme Court waits until the absolute last minute to step in and freeze the lower court's map, aren't the justices themselves violating the Purcell principle?
Yes, like by dropping a shadow docket ruling right before voting starts, the court is actively causing the exact last-minute administrative chaos and voter confusion they claim they are trying to prevent.
Right. Vladeck is pointing out this glaring procedural irony. It's a major point of contention in the legal community right now.
I bet.
Because in many of these redistricting cases, a lower federal court will hold a lengthy trial. They'll implement a new, fairer map months in advance of an election.
Yeah.
The state appeals it, but the Supreme Court sits on that appeal for months.
Just waiting.
Yeah. Then, just days or weeks before the election, the Supreme Court issues a stay. They invoke Purcell to freeze the lower court's map, and they force a reversion back to the state's original, often discriminatory map.
Wow.
So scholars argue the court is applying the principle to everyone except itself, using the threat of confusion to validate maps that lower courts have already found to be illegal.
That exact frustration is leading experts to completely rethink how courts should evaluate these last-minute election changes, right?
Yes, absolutely. Like, there is this fascinating article from the Utah Law Review by a scholar named Harry B. Dodsworth, and it offers a real structural solution to this problem.
Yeah, Dodsworth's approach is so interesting.
He argues that courts are currently treating the Purcell principle as a blunt instrument, right? Like just a flat ban on any late changes whatsoever.
Right.
But he points out that not all late changes cause the same kind of harm. Courts need to look at the specific type of order being issued.
Yeah, he proposes this very elegant taxonomy to replace that blunt instrument. He divides late court orders into two distinct categories: positive orders and negative orders.
Okay, break those down.
So a positive order adds new voting restrictions late in the game. For example, a court reinstating a law that suddenly requires a highly specific form of photo ID that wasn't required, say, a month ago.
Okay, so positive equals adding a restriction.
Right. And a negative order does the exact opposite. It removes restrictions late in the game, such as a court striking down that exact same photo ID law.
The mechanics of how voters respond to those two different orders is where this Dodsworth framework really shines, I think.
Oh, entirely.
Because picture a voter who, doesn't watch the evening news every night. They miss the update about a late court order.
Pretty common scenario.
Right. So if a court issues a late positive order, meaning adding a new ID restriction right before Election Day, our confused voter shows up to the polls without the newly required ID.
Right.
They are what Dodsworth calls under-inclusive.
Under-inclusive, exactly.
So the poll worker turns them away. That leads to actual hard disenfranchisement.
Yes, but consider what happens if a court issues a late negative order removing an ID restriction.
Right.
Our confused voter shows up to the polls with extra ID that they just no longer need.
Right, they brought too much.
Right, they are over-inclusive. The poll worker just checks their name and hands them a ballot. It is a completely harmless error.
Oh, wow, that makes so much sense.
Yeah, the confusion generated by a negative order does not lead to voter chill or disenfranchisement. So based on this behavioral reality, Dodsworth concludes that courts should adopt a presumption of no confusion for negative orders.
A presumption of no confusion. I like that.
Yeah. If a lower court's late ruling is making it easier to vote, or if it's removing a discriminatory barrier to representation, the Purcell principle shouldn't automatically be used to block it.
Because no harm, no foul.
Exactly.
Yeah.
The rationale behind Purcell, which is preventing disenfranchisement via confusion, it simply doesn't apply when the change expands access.
So how did all of this high-level legal theory, like the tension over the Voting Rights Acts, the shadow docket delays, the fear of administrative chaos, how did that all crash into reality in the Supreme Court's June 2026 Alabama ruling?
Well, it culminated in a very dramatic June 2, 2026 per curiam order.
Okay.
The Supreme Court's conservative majority intervened via the shadow docket, and they vacated the lower court's injunction.
Oh, wow.
Yeah, and by doing so, they allowed Alabama to use its 2023 map.
Wait, the map with only a single black majority district?
That exact one. The one that the lower court had found deliberately defied previous orders. They allowed it to be used for the upcoming midterm elections.
What was the specific legal logic the majority used to justify letting that map go forward, especially after it had been struck down by a 3-judge panel?
The majority leaned heavily on that new Calais standard we talked about.
Disentangling race and politics.
Right. They argued that the lower federal court didn't give the Alabama legislature a proper presumption of legislative good faith.
Good faith.
Yeah. Where the lower court saw defiant discriminatory animus in the state, passing another map with only one majority black district, the Supreme Court majority interpreted it merely as the state's legal disagreement with the court's earlier order.
A legal disagreement. Wow.
Yeah. Furthermore, they stated the plaintiff's alternative maps failed the Calais test, because those alternative maps did not respect the state's goal of keeping the Gulf Coast counties of Mobile and Baldwin together without prioritizing race.
Okay. So they used a Calais.
Yes. And finally, they invoked the Purcell principle. They stated that federal courts shouldn't interpose court-drawn maps on the eve of an election just because they think it might be more convenient or marginally fair,
Convenient.
citing the risk of administrative chaos.
The word convenient feels entirely disconnected from the physical reality on the ground here, which we see detailed in the fierce dissent from Justice Sotomayor.
Her dissent was powerful.
It really was. The logistical nightmare she highlights is just staggering. Remember, the Supreme Court vacated this injunction right as the state was preparing its final databases for the election.
Right.
To switch back to the 2023 map, county officials in 3 split counties had at best 7 days to reassign 600,000 individual voters by hand.
By hand. In 7 days.
By hand, before the voter rolls permanently locked. That is 15% of the state's total registered voting population.
It's unbelievable.
And in 2 of the smaller counties involved, there were just 3 election officials available to query databases, manually override precinct assignments, print new poll books, and mail out new voter cards for 100,000 voters.
3 people.
3 people. It is practically impossible to do without errors.
Yeah, Justice Sotomayor framed the situation really starkly. She wrote that the court was faced with 2 paths.
Okay.
Down one path lay an orderly election held under a tested, court-drawn map that protected black voters and that the local election officials were already prepared to administer.
Right. And the other path.
Down the other path lay a chaotic election held under a map found to be intentionally discriminatory, adopted in defiance of a prior court order, and which would require those Herculean efforts by overworked local officials to implement in just days.
And she argued they chose the second path.
Yes. She argued the majority knowingly chose the second path, disregarding both democratic values and the rule of law under the guise of preventing confusion.
Which brings us to what this all means for you as a listener. Whether you are prepping for a legal meeting, studying political science, or, you're just trying to be a well-informed citizen, the key takeaway is a fundamental shift in how elections are governed.
Definitely.
Election laws in this country are no longer just about what is constitutional. They're increasingly about when a court is willing to enforce the Constitution.
Timing is everything now.
Exactly. The timing of a lawsuit, the strategic delays in the appeals process, and the shadow docket application of the Purcell principle, they can literally dictate the balance of power in Congress. Completely, regardless of the underlying legal merits of the map itself.
Right. And looking ahead, this leaves us with a really profound and honestly somewhat unsettling thought to mull over.
What's that?
Well, we are seeing the Supreme Court increasingly demand that race and partisan identity be perfectly cleanly disentangled in redistricting, right?
Yeah, absolute colorblindness.
Right. But what happens in the near future where map drawing algorithms are programmed to be entirely mathematically blind to both race and politics?
Okay, so just pure geography.
Exactly. If those purely neutral algorithms simply group people by geographic proximity and our neighborhoods are historically segregated, well, those algorithms will naturally produce the exact same disparities the Voting Rights Act was originally written to dismantle.
Oh, wow. Because the housing is already segregated.
Right. So if the courts demand absolute colorblindness in a society that isn't colorblind, we have to ask ourselves, can a perfectly neutral process still be a discriminatory one?
If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications. It helps us continue bringing you content like this and ensures you never miss future releases.